of Foxboro Realty. At counsel's table is John Bruner, who represents defendant Apollo. We seek a new trial. If acceptable to the court, we're going to try to allocate our time. I'll speak for approximately the first 9 minutes. I'd like to start, Your Honors, with the issue concerning the so-called intra-trial jury discussion instruction that was issued by the trial court here, and address the question of precisely what the law, the governing law, was with regard to the underlying trial. In 1976, this court decided the Benjamin case, Your Honors. That is binding authority in the context of this case. In Benjamin, the court...
Could I just ask you this question? Even assuming that we were to say this isn't a good idea, or how can you show that that the verdict was affected by this? Because, I mean, I've read you point to questions that were asked of the jurors by of the witnesses by individual jurors, but we don't know whether those questions were the result of the individual jurors' individual thinking or some conversation. I mean, how would we tell?
Your Honor, the primary argument is that we don't have to, precisely for that reason. Jury deliberations are secret, and that is why, although I'll address those questions, and I submit to you they do show an actual prejudice because they are a window, to the extent we have one, into the thinking of the jurors. But all we need to show here under the standard on review is what the cases call a tendency, not an actual showing of prejudice, but a tendency to impair in any fashion any essential element of the jury trial. And the key to this is the Bellino case. The Bellino case, which is, of course is a criminal case written by Justice Qua, specifically adopts Article 15, which of course is not a criminal concept. It is a civil concept that speaks of property rights and speaks of litigation between citizens. Clearly, when Adams put the Constitution together, that was geared toward civil disputes. Nonetheless, Justice Qua, in the Bellino case, expressly adopts over and applies that wonderful, extraordinarily protected standard, perhaps I would submit the highest standard in the law, because it deals with the most important right in the law, the right that vindicates all other rights, the jury trial right. Specifically, the standard, Your Honors, is that reversible error exists whenever a trial judge alters the structure of the jury trial if there is any potential tendency, and I underscore the term tendency, to impair what the Bellino court called the essential elements of the jury trial. And that comes from Bellino, Article 15, and the Vinnie case is a more recent iteration of that. This is not
Does it strike you, though, that if there was a project in which this was tried as one of a number of innovations, quote, and I take it from what I've read that it was with the approval of a single justice, that maybe it isn't so fundamentally structural?
Your Honors, it strikes me that it may not have that may not have been apparent at the time to some folks, but it is very clear to me that because the Bellino case adopts Article 15, we now, the state of the law in Massachusetts is that this standard applies across the board on civil and criminal cases. It is not a prejudicial error or harmless error standard because, number one, it cannot be, because it's impossible. It doesn't, as the Fulminante case of the Supreme Court on the federal side demonstrates, it doesn't make any sense to speak in terms of harmless error or prejudicial error analysis where there's a problem with the structure of the trial particularly concerning deliberation. Also, as I say, Your Honor, the cases, and we've given you a number of them in addition to Vinnie and Fulminante on the federal side, Vinnie's decision of this court, they all show that there is a prophylaxis here. This court's jurisprudence, and again, it's civil and criminal because of the crossover from the Bellino case. This court employs a prophylaxis that says if a trial judge makes this sort of error, and I'd like to get into the three particulars of it in a moment, then it's automatic reversal. The three particulars that I'd like to point...
Mr. McDonough, can I just follow up Justice Botsford's question?
Certainly.
I mean, I understand your reliance on Benjamin. Benjamin had some different facts. It was people outside the jury, and the court dealt with them altogether. Bellino had other kinds of facts. If a trial judge, I mean, we know that there's been a lot of innovation in how judges deal with juries. It's been recommended by many jurisdictions, and if a judge wants to try something, I mean, essentially your position seems to me to be that if you get the imprimatur of a single justice, the judge is proceeding at his or her risk.
I'm sorry, did you say if there is approval of a single justice?
Yeah.
I haven't, first of all, as a matter of record, I haven't seen, I would have thought that there would have been something specifically on the record of this case saying there was some application, even though it's a...
No, but if you object at trial, you could take it up to the single justice, correct?
If you object at trial, I would think at that point your remedy would be to take it up on appeal as we're doing here.
Yes, except that when you're tying with innovation things where there's not any clear law prohibiting it.
I'm sorry, Your Honor, you mean chronologically if a judge had raised this 3, 4, 5 months before trial, then certainly...
No, what I'm saying is the party, if there's any ruling in the court which a party objects to and thinks goes to the fundamental problem, the party can always take an interlocutory order up, correct?
In the middle of a trial, Your Honor?
Sure.
It happens all the time in criminal trials.
I'm sorry?
It happens all the time in criminal trials.
Well, Your Honor, my reading of this Court's jurisprudence on interlocutory appeals, certainly in the civil context, is if you have a remedy later in terms of appealing.
I understand that, but what I'm looking at is not so much what happened in this case, but going forward, because I think I understand your point that it's very difficult to show prejudice because we don't go into what the jury did. So essentially, one is faced with the prospect of a judge doing something which is not clearly prohibited, at least arguably not clearly prohibited by the law, and then, you go through an entire trial. This was a lengthy trial with lots of expenditures, and essentially you're saying, well, if we agree with you, then we just upset the whole trial. And that's a lot of, I don't know of another case in that kind of posture.
Well, it's not, I don't know that there was anything else that the lawyers in this case at trial, excuse me, Your Honor, could have done other than to immediately object as they did and preserve the record as they clearly did.
Which they clearly did, yeah.
Your Honors, if I could, I'd like to turn and give 3 specifics as to how this standard was violated. These are essential elements of the jury trial. It is, I think, undisputable that under the McSweeney case in particular, the presence of the trial judge at anything having to do with the development of the evidence, and more specifically, as in the Fitzgerald case, any issues or exercises concerning elimination of juror confusion absolutely require the physical presence of the trial judge. It's automatic reversal if the trial judge is not there. That's an abdication of the trial judge's duty to oversee anything having to do with supposed confusion. And
so even when the jury is deliberating, they can't resolve confusion themselves? Is that what you're saying?
No, not during, after the final charge and the jury is deliberating, Your Honor, that's sacrosanct. But during trial, before what I am referring to as deliberation, although it's clear to me that deliberation occurred prior to the charge in this case for the reasons we've alluded to, those questions that we refer the court to from the jurors. No, I'm saying during the course of the trial, that is the presentation until the close of the evidence and final charge, it's the judge's duty to be there. There's no excusing that. And what happened here is the trial judge candidly stated in his instruction, you may have occasions to clarify things. That is another way of saying eliminate confusion. That's the trial judge's duty. So that was clear error. Second, and by the way, the Brito case, the jury question case, is a very interesting contrast here. Your Honor, as the court instructs in Brito, jurors should not even be discussing the questions that they want to give to the judge to ask of the witnesses. If that is appropriate, and it clearly we say is, then it is bizarre to then tell jurors when they're looking at questions to be submitted for the judge's approval and a potential objection by counsel to let the jurors then go into the deliberation room and engage in free-willing discussion on not only questions but having a Q&A session. Just a couple of, if I may, Your Honor, says the shift in the burden of proof, that's another fundamental problem. And the third would be the avoidance of prejudgment. I see my time is running, Your Honor.
And you've briefed it well, including in the reply brief. I think all those points are there.
Very well, Your Honor. Thank you very much.
Thank you, Mr. McDonough. Good morning, Mr. Gannett.
Good morning, Your Honor. I represent the appellant Kelly, Apollo Security in this matter. To me, I really take a fairly simple and straightforward view of it. We have in this Commonwealth a clear rule that juries are to be instructed not to discuss the evidence until the end of the case. That rule has prevailed for a long time. It's consistent with the rules in most other jurisdictions, and to all appearances, it has worked very well in this Commonwealth. There is no indication that we have dysfunctional juries. There is no indication that day in, day out, our juries in this Commonwealth don't render sound verdicts in cases where there has been no significant error during the trial. So the fact that we have a rule that has worked well, of course, doesn't mean that the rule can't be changed. But if you're going to change it, I would think that it would be necessary, especially in an area as important as this, that you have sound, reliable information to indicate that the substitute is going to be even better. And you don't have that. There have been a lot of articles written, a lot of commentary written, and there are a lot of people who question the traditional rule, who raise hypotheses about why a different rule might be better, but there is no actual data to show that the proposed new rule will be better or not, or even will not be a derogation of what we have.
Well, in your view, how would one ever get the data, since you would never allow it to happen without the data? I mean, isn't it a kind of catch-22?
Well, of course, in the state of Arizona, there have been 2 studies, very flawed studies, but nonetheless, they have generated some data.
Yes.
And what does the
But
data?
you discount that data, right?
I discount some of the characterizations, but data was generated there, and more data could be generated by that means.
Data was generated here. Admittedly, not a lot, but some, and the jurors found it very helpful.
If you are referring to the Massachusetts study,
Correct.
I think what that showed is that all of the jurors, taking into account all of the jurors who submitted questionnaires, about 40% said that they thought jury discussions were or would be helpful. About 40% said they thought they were or would be unhelpful.
Well, I'm just reading a figure from that study that of the jurors who participated in the 6 trials where this was happened, 93% reported that being allowed to discuss the evidence was somewhat or very helpful to them.
That's correct, but how do they know what it would have been like if they hadn't been permitted to discuss?
Well, vice versa is true as well, isn't it?
That's correct. So that's why you have to take the views of all of the jurors who participated in all of those trials. And given that choice, about 40% said we think this would be unhelpful, about 40% said helpful. So it's a wash based on that data. Now, the studies that were done in Arizona would have permitted the researchers to determine whether there was, in fact, some helpfulness here, because one of those studies actually filmed the deliberations. And so it would have been possible to determine whether the deliberating juries in the discussions group actually understood the evidence better than in the no discussions group. Unfortunately, the researcher who wrote that report chose not to do that. Instead, we're left with the self-report study that was done by Professors Hannaford et al. And what that study found was that there, in fact, was no difference in the actual understanding of the evidence, expert evidence and other evidence, between the 2 groups of jurors. So the existing empirical data, and I don't say that it's conclusive or dispositive, but it's all we have, the existing data shows that this type of innovation does not help jurors. They may like it. Of course they like it. Anybody would like being told you can talk about anything you want.
Hi.
Well, who's to say what, I mean, are you going to be the arbiter of whether it helps them or not? Don't you think they might have a say in that?
What I respond to that is that the only data we have from the studies, the empirical studies that have been done in Arizona, the only data shows that it was not helpful to them. We can speculate that maybe it would be, maybe it wouldn't be, but a change of a rule in an area as important as this, a rule that has worked very well for a long time, should not be based on wishful thinking, should not be based on the hope that maybe this will be better, because the data from the Arizona studies shows that permitting these types of discussions has inimical effects. Those studies demonstrate that jurors told that they can discuss the evidence during the trial, discuss it among subgroups much, much more frequently than juries who receive the typical instruction. It shows that juries don't limit themselves to just clarifying evidence, talking about primary facts. As often as not, and maybe even more often than not, they talk about credibility and the weight of the evidence and the inferences to be drawn. And very, very frequently they express opinions about what the judgment should be. They do the things that Judge Brassard told these jurors not to do. And the reason he told them not to do it is because those things are universally recognized to be a threat to the integrity of jury verdicts. And the rule that is being proposed here, based on the data that we have, is going to encourage those inimical effects. And I suggest to you that if our existing rule is going to be changed, it should not be done by way of judicial decision. It should be done on the basis of empirical study by a commission. Thank you very much, Your Honor.
Thank you, Mr. Glennis. Good morning, Mr. Meyer.
Good morning, Your Honor. May it please the Court. The studies which have been done in Massachusetts and elsewhere have indicated that the efforts to clarify for the jury information they have found helpful. The Arizona study, which was just referred to, in fact, post that study, there was in fact an adoption of the ability and instruction for a juror to for jurors to be able to discuss the evidence, not to deliberate on the evidence, but simply to discuss for purposes of clarification. The Massachusetts project, which was referred to earlier, found well into 90% that the jurors found it helpful or somewhat helpful in their ability to better interpret the evidence. Judge Brassard, in this case, was in a position of facing a lengthy trial. There were more than 33 witnesses. There were more than 50 technical exhibits.
Mr. Meyer, isn't it a kind of a slippery slope between clarification and the beginning of some sort of resolution in terms of the ultimate question?
One would think that that may be a possibility. None of the studies that have been done, the sociological studies, have indicated that any prejudgment has ever occurred or concluded that any prejudgment has occurred which infected in any way the jury. In addition, in this particular case, Judge Brassard took very particular safeguards in his instruction, which go even well beyond what is now the pattern instruction, a model instruction from the Superior Court as authored by Judge Brady. And he took those instructions. He told this jury that they didn't even introduce the concept prior to their receiving evidence. Once they began to receive the evidence, and we've outlined this in our brief, he told them they could discuss the case without deliberation. He said they could discuss the case only with the foreperson present, which he then appointed. They could not break off into small coteries. They could not break off into small groups. They could only do it as a group. And then he went further as to give examples as to the kind of misinformation that can occur which they are allowed to clear up and what they are not allowed to clear up. He gave an example of if they didn't hear whether a road was icy or not icy, might have missed a word, whether something was, he didn't use this example, but I will use it, 15 or 50? If one didn't hear that, could a jury go into a room and then say, did he say 15 or 50? How does that fit into the hypothetical that we're now hearing about? I don't remember that being the evidence. He was very specific in telling them they could discuss but not deliberate, that they could clarify yet not come to any conclusions or express any opinions under the policing, and only under the policing, of all the other jurors and the foreperson just existed. So with these safeguards, I believe we stop that potential of falling into deliberations. And as said, none of the studies ever indicated that there was a conclusion that prejudgment did exist or that the jury failed to follow instructions.
And I don't know this, but with respect to the Arizona studies, Mr. Burnett says that the likelihood of talking to others outside of the jury or other problems was greater when intra-trial discussion was allowed than when it wasn't. And I guess my question is, A, what you have to say about that, but B, is it clear that in those, in Arizona, the ones that were being studied, the same cautionary instructions were given? Do you know?
There were no instructions were given anywhere near as clear and concise as Judge Brassard's instruction. I mean, the case that is presented to this court today is probably the clearest case with the clearest instructions that's been heard anywhere in this country. I mean, there are a number of cases and a number of studies, but this is right on point with all the instructions that one could give, no external influences, no infection of the process. It wasn't a casual statement by a judge, which we see on occasion in some of the cases. This was well thought out. It was identified early. It was specifically referred to. It was re-referred to during the course of the trial on numerous occasions to explain to the jury what they could and could not do. And there's no evidence that they even did it, let alone didn't apply the instructions. Your other question?
Does the record reflect how long the jurors all spent together and not in the courtroom? Is there any indication that there was a great deal of time that they were all together in the jury room and not in the courtroom?
Before deliberation?
Before deliberations.
There's no indication that this jury ever, and they were allowed not to, discuss the case before.
But I mean,
there's no
whether or not they did it when they were together, do we have any? Does the record reflect how much time passed between the court officer saying the jurors are all here, Your Honor, and the time in which they walked into the courtroom and the time in which they were waiting because of discussions about the charge or something else? Is there any indication of how long a period of time they had the opportunity to have these so-called deliberations?
My memory of the record is that the jury responded in a timely way when asked to come out. They went home on time. They didn't, and they had at the invitation of the judge the opportunity to stay after. They never did, to my memory. They never asked to stay during lunch. There was there's no evidence that they ever actually employed this technique in this particular case, let alone abused the instructions that the court gave them.
Didn't a judge tell the jury at one point to stop talking, clarifying among themselves? Doesn't that suggest that the judge concluded that something wasn't operating the way he anticipated?
In fact, what Judge Brassard was doing at that point was he didn't even instruct them until the evidence started, and then he stopped them at the conclusion of the evidence. Since there would be no longer reason or need for clarification of a witness's testimony, he stopped them at the conclusion of the evidence. So the timing of what Your Honor is referring to was that he began at the beginning of the evidence and he stopped them at the close of the evidence and then said we were going on to closing arguments. So it wasn't in the middle, and I recollect no concern at all that this was abused or even employed in this particular case.
Is there anything in the record that indicates why Judge Brassard decided he was going to employ this experiment without first getting the consent of the lawyers on both sides and without talking about what kind of procedures we were going to follow before the trial started as opposed to after the trial started?
He did discuss before the trial started that he had intended to do this. We also had interim commentary, which Judge Brassard allowed, which was not objected to. The judge also allowed questions from the jury. There were jury notebooks, and there were also juror books. So there were a number of elements of what one might refer to as innovative trial practices over the course of the last 15 years which were employed. This is the only one which is presently objected to.
Can a judge choose to ignore standard jury instructions in the interest of improving the system?
This, as far as this was a discretionary matter at this time, and that unless the standard was referred to before, we believe in the Brito case, which is the case this court worked on of the questions, that this one would have to show an absolute prejudice. The standard instructions are suggested instructions, and in fact the standard instruction now in the pre-charge involves an instruction regarding allowing jurors to deliberate. So whether or not within a judge's discretion they have the opportunity to either use or employ this method for juror clarification in the appropriate case is usually left to the discretion of the judge. Pattern jury instructions clearly are adjusted on a court trial-by-trial basis depending upon facts or circumstances of the particular trial justice who's involved in delivering them. So I believe that it would not be an abuse of discretion, let alone an absolute abuse of prejudice in this case, regardless of this court's outcome. But looking to what the benefits are to allowing a jury, the alternative of not allowing a jury to ask a question, to seek clarification, to clear up some type of confusion with 50 technical exhibits in a case, which may in fact be a linchpin for further information, for further hypothetical questions, for further testimony, is to say to them they can't ask a question, they can't talk to each other, they can't clarify, and they may have to wait days, weeks, months.
Well, that's
in
not,
a
I mean,
case.
couldn't Judge Brassard have said, if you're confused about the evidence, please write it down on a note and furnish it to the court officer, and then he'll give it to me and we'll share it with counsel so that counsel are all aware of whatever confusion you may have?
Absolutely. And I believe that certainly is one of the avenues which would be available to any trial judge to allow them to write their questions down. And in fact, by allowing juries to ask questions, as this court has allowed, that is another method. But the problem occurs is when we get further down the road into the trial and the witness is gone and the jury may be confused as to an earlier question, or maybe a missed word, that they be allowed to at least ask amongst themselves altogether, did we hear that? What do we think about that? Is there a clarification? So I guess an answer to the question is there are a number of avenues which can be proceeded down, but this is certainly an effective one and one which would help jurors reach an understanding of what they are hearing, not come to a conclusion as to what they feel in the ultimate, as to the ultimate question. In fact, Judge Brassard gave them very specific instructions. For instance, in the icy road decision, was it icy or wasn't it icy? But you can't discuss how the driving was going. Was he going too fast or not too fast? So those kinds of differentiations by Judge Brassard in this case were made, I think, quite clear, and is one avenue for the jury to be able to work out a theory without getting necessarily through the deliberative process in the end.
Should the foreperson of the jury be required to keep a log or a diary of when these deliberations started and ended, and what the particular point of confusion was, and then present those to the judge immediately after the discussion took place, so that the lawyers can understand where the confusion lay? Well,
we've had a long tradition of not reading jurors' notes, not taking the notes out of the jury room. We seal them. And these are more discussions of fact as opposed to deliberations. I mean, one could have a stenographer present in the jury room at any time to record those kinds of things if it was appropriate. But the juror, this is a very closed environment, and I believe we respect the jury's integrity in coming to their own conclusions as they see the facts and their own conclusions as to what a fact was that was testified to. And I don't see, nor have I seen addressed in any of the studies or cases, the necessity that this be reported to the judge that there was a discussion. To the contrary, the studies have indicated that these have been very helpful discussions to the extent that they exist, not deliberations, but discussions, clarification, not conclusion. And when we reach that point where they are successful and they are effective, I don't believe any record needs to be made of that, any more so than we would make a record of their deliberations.
Does it make a difference that in Brito, a written question has to be submitted to the judge and then discussed with the lawyers?
I think the well-reasoned thought behind the Brito case is that we want to sterilize some of the questions as they come through, as they go to the witness, the same way that a question from a lawyer may be objected to and be admitted or not admitted based upon what was being said to the witness. And so that's the well-reasoned, that's an actual question to a witness. And I think that's the differentiation between what we're talking about, which is clarification of a fact. Maybe somebody misheard something, maybe the wind blew, maybe somebody coughed. Maybe there's a mishearing of a fact, which is what can occur during course of any testimony, versus a question which is now being put to the witness, and the jurors are acting somewhat in the inquisitory sense, and that has to be filtered through the judge, as this Court has said, and as a normal practice now, for the purpose of allowing objections, and I should say, in regard to juror notebooks, in regard to juror questions, and in regard to any of these innovative practices. These aren't mandatory, and nobody has said they were mandatory. Many judges still don't allow questions from the jurors to the jurors to the witnesses. Many judges don't even some don't even allow juror notebooks. It's not a mandatory issue. These are simply options that, in the right case, where a judge feels it's appropriate, he has the discretion, or she has the discretion, to be able to make a presentation to the jury which would allow them to more efficiently, more intelligently understand the facts they are listening to and not get lost because they missed one word or 3 words or a concept and then go on 3 days later and not be able to
Let me interrupt you. At what point did the lawyers know these were the rules?
Before it started, Your Honor.
Just at the beginning of the trial?
At the beginning of the trial, Your Honor, correct.
Can I ask something that Justice Sponsford asked it earlier, and I wasn't sure I had noticed this. There was no approval by a single justice in this case. That was the project under which some of the experimentation took place. That didn't happen in this case.
That did not happen in this case.
I meant the project. Wasn't there a single justice who approved the project?
The Massachusetts project, Your Honor, there was an approval by a single justice.
Including this intra-trial questioning as one of the innovations that was going to be used.
Exactly, Your Honor. That's exactly right. And I think it was 93%, I believe, was the number that found it either helpful or somewhat helpful. I thank you very much for your time.
Thank you, Mr. Ryan.